Hello, everyone, and welcome to today's webinar. My name is Debbie Brenneman. I'm a partner in Thompson Hine's Labor and Employment Group, splitting my time between the Dayton and Cincinnati offices. And I am delighted to be joined today by my labor and employment colleague, Cleveland associate Brittany Mallow. For the next hour, we will discuss the final rule recently issued by the Federal Trade Commission that essentially prohibits employers from using non-compete agreements. We'll examine the final rule requirements, as well as analyze the ongoing legal challenges and strategies to navigate the current and uncertain landscape. Before we get started, just a few housekeeping items. Today's program is being recorded, and we will send a link to all attendees, including the PowerPoint, within 48 hours of today's presentation. If you have questions during the webinar, please feel free to use the question box located in the control panel on the upper right side of your screen. If we have time when we get to the end, we'll answer as many of those as we can, or we can follow up with you later. But thank you again for your interest, and let's get started. I'm going to turn it over to Brittany to kick it off to talk about those days that we used to enjoy when non-competes were widely enforceable. Brittany?
Hi, thanks, Debbie, and thanks again to everybody for joining us. So yeah, back in the day, you could have a non-compete and it was considered valid and enforceable as long as the agreement was supported by consideration. It contained restrictions no greater than necessary to protect the employer. It didn't impose an unreasonable hardship on the employee, and it contained reasonable temporal and geographic restrictions. Excuse me. One thing to keep in mind, there's always been kind of different definitions given by states through the court system and litigation of what exactly is a permissible geographic restriction, what amount of time is permissible, and we've kind of seen that played out through the courts in the last several decades. However, obviously now with the FTC's final rule, we've gone to kind of a bright line rule and getting away from this traditional analysis. And like I mentioned, non-competes have been under increasing attack by local and state legislatures. Many states have implemented laws forbidding or significantly restricting their scope. Again, a lot of those focused on the geographic and temporal restrictions I mentioned, but some of them have already outright banned non-competes. For instance, look at California, DC, North Dakota, and Oklahoma. In Oklahoma specifically, non-competes have been banned, and the law says that the employee shall be permitted to engage in the same business as that conducted by the former employer or in a similar business as that conducted by the former employer, as long as the former employee does not directly solicit sale of goods, services, or combinations of goods and services from the established customers of the former employer. So as you see there, that kind of gets into the non-solicitation clauses that you see a lot coupled with the non-competes. But those are the 4 states that have outright banned non-competes. A few months ago, Debbie and I gave a presentation on the proposed final rule. And at that time, there was pending law sitting on the New York governor's desk to be signed that would have added New York in this mix. But she actually vetoed the bill to be rewritten to kind of rework some restrictions there. But we do expect this year for New York to kind of republish a proposed final rule, and eventually will also join the fray with this list here. There's some other state laws that govern where you can restrict the temporal component or the geographic component. Some salary thresholds, as you see in Oregon, is a 12-month maximum. The salary threshold is $100,533, and the employer must pay the former employee during the restricted period. Nevada prohibits non-competes for hourly employees. A few other states here. Illinois has a $75,000 salary threshold, and it must be supported by 2 years of employment or other adequate considerations. And those restrictions there in Illinois also extend to non-solicitation provisions. Maryland has a salary threshold of $31,200 annually, which equates to $15 an hour. And Virginia prohibits non-compete specifically for low-wage workers. And that includes interns, students, and certain independent contractors as well.
Yeah, and so then enter the fray with the Federal Trade Commission. So when President Biden was on the campaign trail, one thing he talked about was non-competes. And early in his tenure, he encouraged the FTC to take up the topic of non-competes and review them. That sat around for a couple of years, and we thought maybe nothing was going to happen. And then all of a sudden in January of 2023, the FTC jumped into the fray and jumped in hard with a rule, proposed rule that was, again, a near total ban on non-competes. We expected that there was going to be a very quick vote after the public comment period. I think there were about 27,000 public comments that came in, however, and the FTC ended up delaying the vote on the proposed rule, purportedly to consider some of the comments that were made. When it issued the original guidance, the FTC specifically had sought comments on a couple of ways to limit the rule that would look more like what some of the states are doing and what make more logical sense, frankly. It debated, or it sought comments on setting salary thresholds above which non-competes could be used. It considered whether to allow the use of non-competes for senior executives, but it appears that those comments were not considered, well, considered, but promptly dismissed, because the final rule that was issued on April 23rd was, again, just very, very, very similar to the proposed rule, and is virtually a total ban on the use of non-competes by employers for any workers. And we'll dive into that a little bit more in a few minutes. So the FTC has articulated that its motive is really twofold. One, claiming that workers' compensation and mobility are really stymied by non-competes. They have this non-compete, so they're bound, and the employer is in control of the kind of salary increases and bonuses. And so if they don't want to start over again, they're really bound by these things, kind of handcuffed to the job. Interestingly, in the 500 plus, really nearly 600 pages of guidance published with the final rule, the FTC spends a lot of time with quotes from folks who made comments, and most of those, if nearly all of those quotes that the FTC uses are quotes from lower level workers, delivery drivers, people with very low wage earnings, and really did not highlight comments from employers with, who discuss a lot about the concern with regard to their higher level employees, their creative employees, their C-suite employees. That didn't seem to get much consideration by the FTC. The second real foundation that the FTC articulated as its motivation is suggesting that new businesses have a difficult time breaking into industries in which a lot of the labor force is locked into existing employment agreements. And the FTC claims that with this ban, something like 8,500 new businesses will be able to be created. So taking a look at the rule itself, it is retroactive with one teeny tiny little sliver of an exception that Brittany will talk about in a few minutes. Also, I note that the final rule does not apply to certain industries, banks, insurance carriers, and, a few businesses that are not governed by the FTC, but for virtually all employers, it is in play. It would go into place in August, and it would be retroactive. It would make existing agreements unenforceable, and employers are required to provide notice. Now, one small change to the proposed rule, the proposed rule would have said that those prior agreements are all just void and unenforceable. A little bit of a back off of that. Now what the FTC is saying is, okay, employers, before the effective date, you need to provide notice to your employees who may be bound by non-competes that those provisions are not enforceable and you will not enforce them. And they have a template form available on the FTC website to use to provide that notice. So that has to go out prior to August of this year. But I wouldn't be sending out those notices just yet, because as we'll talk about a little bit later, there are some pretty significant legal challenges going on, and who knows what this is going to look like come August of this year. The rule does make it clear that it overrides any state laws, so states that have some restrictions but not complete prohibitions, this just wipes all of those out. With regard to the agreements themselves, again, it will apply to all workers, and employers do have until the effective date to provide that notice. Importantly, if you have agreements that contain, as most employers do, not only a non-compete provision, but also non-solicitation and confidentiality provisions, those provisions would remain in effect, subject to some discussion we'll have. So you would not have to have an entirely new agreement, but you would have to give notice that the non-competition provisions are not enforceable. So exactly what is covered when we say non-competes? Well, the rule defines a non-compete clause as a term or condition of employment that prohibits a worker penalizes a worker for, or functions to prevent a worker from seeking or accepting work in the U.S. with a different person or company where that work would begin after the conclusion of the employment that includes the term or condition, or operating a business in the U.S. after the conclusion of employment. So a couple of things here. First of all, according to the guidance, the FTC was considering even including concurrent employment. In other words, that you as a current employer could not prohibit your employee from engaging in competitive employment while they're working for you and you are paying them. At least the FTC backed off at that. So you see the language that it begins after the conclusion of the employment. Another section of this to focus on is that the non-compete clause is something that would, as a function, prohibit them from going to work. So non-solicitation and confidentiality provisions, which we'll talk about again in a few minutes, could come under this if they're too broad. So we'll talk about that a little bit more. In terms of the individuals who are covered, it's any worker. That's employees, independent contractors, externs, interns, volunteers, or sole proprietors who provide a service to a client or to a customer. And the rule applies to any person or employer, including a natural person, partnership, corporation, association, or other legal entity within the commission's jurisdiction. So pretty much the whole spectrum there. As I mentioned, there is a teeny tiny exception to this to allow the continuation of non-competes for a very narrow excuse me, window of employees. And I will send it back to Brittany to talk about that.
Thanks, Debbie. Yeah, so the small exception is for senior executives, and as with most terms that are used in the final rule, it's, well, how do we define senior executives? So first of all, senior executive is defined by a two-part test in the final rule. First is if it's someone in a policy-making position, which is also a defined term we'll talk about in a minute, as well as having total annual compensation of at least $151,164. And for those individuals that meet this test, those non-competes that exist prior to the effective date may remain in force. So this retroactivity portion of the final rule will not apply to these individuals that meet the test and have non-competes prior to the effective date. So this is the most important exception, especially for higher ranking C-suite executive level employees. In defining total annual compensation, the final rule does make clear that this includes bonuses, compensation that they might receive, such as a bonus tied to performance that is paid pursuant to any contract agreement. So not just the salary. The rule also allows for the entire amount of such bonuses to be credited to total annual compensation. Again, this will increase the likelihood of capturing those highly compensated policy-making individuals who have both a salary and bonus compensation structure. So what is a policy-making position? The rule defines that as a business entity's president, CEO, or equivalent, or any other officer who has policy-making authority, or a natural person who has policy-making authority for the business entity similar to an officer. Then they define policy-making position further, stating that an officer of a subsidiary or affiliate of a business entity that is part of a common enterprise would also meet this definition. And finally, the policy-making position definition states that a natural person who does not have policy-making authority over a common enterprise may not be deemed to have policy-making position, even if the person has policymaking authority over a subsidiary or affiliate of a business entity that is part of the common enterprise. So that's kind of really in the weeds here on meeting the definition, but it is kind of parsed out in the final rule. If you want to take a closer look, we can obviously talk about that offline of which positions would meet this test and which wouldn't. So what is policymaking authority? The rule does give a definition for that as the final authority to make policy decisions that control significant aspects of a business entity or common enterprise. The definition further states that policymaking authority does not include authority limited to advising or exerting influence over such policy decisions or having final authority to make policy decisions for only a subsidiary of or affiliate of a common enterprise. So again, this definition, like I mentioned, there's a lot of terms defined within the final rule. There's still portions of this definition that come into question. What is a significant aspect of a business entity? Policy, what is a policy decision? We're really going to have to kind of wait and see how this all plays out. A lot of it, we'll just kind of have to see how it unfolds and how they continue to define these terms, both not only in the final rule, but as litigation proceeds.
Yeah, and I think it's interesting, before I get to the sale of business, it's interesting that in the guidance with regard to senior executives, that the FTC stated that non-competes with senior execs are not likely to be exploitive or coercive because those executives are likely to have negotiated the terms of their employment and often do so with the assistance of counsel. So, because they're likely to have bargained for a higher wage or more generous severance package in exchange for agreeing to the non-compete, the commission said, okay, well, they're not exploitive or coercive, but nonetheless don't allow them on a go-forward basis, are only letting them survive if they exist right now. And that brings me to another thought with regard to what do you do between now and when the rule is slated to take effect. It would seem that if people are being onboarded into a senior exec role, agreements can still be entered into with them during that period, as long as if the rule does survive, that notice is given that it's no longer in effect. Certainly probably easier to negotiate that non-compete with an onboarding exec now than mid-course during employment if the rule falls through. But that's something that a lot of us who watch this have been discussing. There are some other exceptions with regard to what does not fall within this. So exempt from the rule are non-competes in connection with the sale of a business. Now, the proposed rule hinged this on the individual having a 25% interest in the business, and the guidance to the proposed rule said that the commission might be considering moving that down to as low as 10% or up as high as 50%. But in the final rule, we see that this specific percentage did not come through. So as long as the sale involves a disposition of the person's ownership interest in the business, so whatever their interest is, or all or substantially all of a business entity's operating assets. So that is exempt from the sale also. There's also a good faith exception to this, which strikes me as a little bit odd, but it says that there's a good faith exception, that wouldn't be an unfair method of competition under Section 5 to enforce or attempt to enforce a non-compete where a person has a good faith basis to believe that the non-compete ban is inapplicable. So I guess if it's, an entity thought they fell within one of those industries not covered or otherwise somehow exempt, that there is a good faith exemption. And before I move on from the slide, there are a couple of other exemptions that are not in the slide, but also non-competes are still permissible between franchisor and franchisee. And something else that is not considered to be a non-compete is garden leave agreements. So these are things that are very commonly used by our European clients, but don't see so often in the US. And that is an agreement to basically pay somebody to sit on the sidelines for a period of time and pay them out to do so. So the FTC declined to talk about every potential factual scenario that may fall within this, but it noted that an agreement where the worker is still employed, still receiving the total annual salary and benefits on a prorated basis is not a non-compete, even if that worker's duties or access to colleagues is even entirely eliminated. So if they're technically still on the books as an employee, they're doing nothing, you've taken away the computer, you've cut off all access, they can't come into the office. As long as you're paying them, that's a garden leave, and that's not considered to be a non-compete, at least according to this guidance from the FTC. With regard to bonuses, the FTC says, that if a worker doesn't meet a condition to earn a particular aspect of their compensation, like, performance-related bonus, then the FTC would still consider that arrangement a garden leave and not a non-compete, again, as long as that employee is getting the salary and benefits that they would otherwise receive. A couple of other notes about the rule. The ban does not apply where a cause of action related to a non-compete clause accrues prior to the effective date. So if somebody goes out and violates their agreement on August 1st and the agreement goes in, or the rule goes into effect on August 21st, then an action could still be maintained. And the FTC was clear that ongoing litigation seeking to enforce a non-compete is still lawful. So again, in this window, it appears that enforcement actions may still be maintained on existing non-competes, according to the laws and regs that are in place in that particular state, but the rule would not ban that type of ongoing litigation.
Thanks, Debbie. And what I'm going to get into next is really a response to several questions that we've kind of received from existing clients since the final rule came out, and something that wasn't initially thought of or kind of isn't something that comes to the forefront unless you work with these agreements as being impacted by the final rule. But the FTC even noted in its in a final rule and guidance that many existing deferred compensation contracts may have been negotiated to include non-competes or forfeiture for competition clauses, and they understand that those might not be easily separated. They did reiterate, though, that the final rule allows existing senior executive non-competes to remain in force, and the guidance includes a discussion in the comments where it goes through, just like it does with many of the other comments, hey, we got all these comments that say X, you're concerned about this, but ultimately they did state, as they did with many other comments that were raised, that they see no reason why deferred compensation, including for retiring workers, cannot be used without a forfeiture for competition clauses. So basically, if this senior executive carve out that we just talked about doesn't apply, the FTC said basically that's tough. We don't see why you would need a forfeiture for competition clause within these types of deferred compensation, including for retired workers. So basically they kind of just wafted their hand at those comments, but that will have an impact and something that's not immediately considered by employers, but certainly will be subject to the notices once the final rule goes into effect. Leading up to that, before it does, employers must issue notices to employees who have any type of non-compete provision. So it's important to keep in mind that these types of deferred compensation contracts will also be included in that. So we've told you what isn't permissible, but let's get into now what is permissible. Confidentiality agreements and non-solicitation agreements, those provisions are typically tied into employment agreements that include non-competition provisions. The confidentiality agreements and non-solicitation provisions, those will all remain permissible with one exception. So you have to watch how they are crafted because they cannot constitute de facto non-competes. And the final rule gives a little further elaboration on that, stating that because these other provisions, confidentiality, non-solicitation, if they have the effect of prohibiting the worker from seeking or accepting employment with a person or operating a business after the conclusion of the worker's employment, then it would be deemed a de facto non-compete, and at that point it will also be a violation. The final rule is it will go into effect 120 days from April 23rd's issue date, so on or about August 21st, 2024. Again, as we'll get into, there's several challenges, so this is what's being proposed and projected. However, we do not expect that to hold. Multiple groups have filed litigation already to attempt to block this rule. A few of the lawsuits. So the first one was filed the same day the final rule was issued in the Northern District of Texas by a global tax prep service called Ryan. There was also an action filed by the U.S. Chamber of Commerce in the Eastern District of Texas the following day, and that seeks a preliminary injunction and stay on the effective date. And then later in the week, we saw a small business in the Eastern District of Pennsylvania file an action as well. Some specific legal arguments that are included in these suits claim that the FTC lacks the authority to issue the final rule in the context, and that it's a sweeping abuse of the FTC's authority under Section 5 of the FTC Act, and that this basically opens the door for the FTC to regulate virtually anything. So there's a huge concern in the business community about that. These suits claim that the final rule is impermissibly retroactive. It violates the Administrative Procedures Act. It's not rationally connected to economic data. And something on that, there's a lot of talk in the final rule elaborating on, you know, we have to put this in place because if people aren't able to go to a competitor or create a new business, then that kind of prohibits economic growth. But these business groups will actually say the opposite, where without these protections in place that are provided by a non-compete, that actually has a negative impact as well. So we have kind of competing data, so it'll be interesting to see how that plays out and how that's taken into account as litigation proceeds. Another legal argument is if it was statutorily authorized, the rule rests on an unconstitutional delegation of authority to the agency. And again, that this was just arbitrarily chosen without duly considering alternatives. And as we know, it's an election year, so that's another important thing to keep in mind as we move towards this projected effective date. Really, the next president and their administration, if it changes or if it stays the same, is likely going to have a large impact on responses to this litigation and kind of how this is going to play out over the next couple years. So that's important to keep an eye on as well.
Yeah, thanks, Brittany. A couple of things about those lawsuits too is it looks like the action brought by the Chamber of Commerce out in Texas, it looks like briefing, what I've seen, the briefing schedule is pretty tight, and it looks like we could have a decision there by that court maybe in early to mid-June. Also, the suit that was brought on Thursday in Pennsylvania in a federal district court, the judge assigned to that is a Biden appointee. So I don't think that lawsuit has very good chances. Could set up a circuit split that could take this all the way to the U.S. Supreme Court. So it's going to be a very interesting landscape ahead of us. And so the question is, you know, what to do now if you're an employer? And I would say first, don't panic. And certainly don't start sending out notices in advance of August, because we don't know what it's going to look like. And if you send out notices and say your non-competes are not enforceable, and then the rule falls to the wayside, it might be pretty tough to go back and get those folks to sign up to non-competes again. So, you know, what you do need to do is stay in close contact with your legal counsel, stay up on the developments, and, you know, be prepared for that. But in the interim, it's also important, if you haven't already been doing so, review your existing agreements. What do you have in place? Are they up to date, even with state requirements that may remain in place if this rule falls by the wayside? Do you have good language in those agreements? Consider and maybe have ready alternative agreements that may be a more fulsome version of your non-solicitations and confidentiality provisions, and also talks more about your trade secrets, which we'll talk about in a minute. But make sure that you have good alternative agreements that are ready to go for new folks who are coming in if you need to, or if you make the decision to reissue all of your agreements or send out new agreements. And also just make sure that you do have a mechanism in place for providing the required notice. So who all has an agreement? Sometimes this is difficult for companies that have, made some acquisitions and you're rolling in a few different companies, and, the executive group or HR may not be familiar with who all even has non-compete agreements. So you need to find that out. Who all has provisions in their deferred compensation agreements? So get a list of who would be required to get notice, start getting that together so you have it ready, but don't be premature with it is what I would say. With regard to confidentiality provisions, again, you want to make sure these are good, and you want to make sure that they're not too overbroad. As the commission stated, if the non-solicit or non-disclosure agreements are too broad and they look more like a non-compete agreement, then they are not going to be valid. So going to the next page quick, and then we'll maybe come back to this. The non-disclosure agreements under the final rule says you can't use an NDA that prohibits an employee from using information that either arises from their general training, knowledge, skill, or experience gained on the job, or is readily ascertainable to other employers or the general public. So it really has to be proprietary information shared with them for reasons in connection with their employment. And if it's too broad, then it could be functioning as a non-compete. The commission gave an example that if an NDA bars a worker from disclosing in a future job any information that is usable in or relates to the industry in which they work, that would be a de facto non-compete because it would effectively prevent the worker from working for another employer in that industry. So just backing up a minute for what you should be looking at for your confidentiality agreements, make sure that there is a provision really defining that agreement, defining the confidential information. I see too many agreements that just gloss over confidential information without really saying what it is. It's important that you define that for a couple of reasons. You want the employee, number one, to know what it is that they should be protecting. And if there is ever an enforcement action based upon the confidentiality agreement, you want the court to see that you were very explicit in what is your confidential information. Of course, you're going to say it includes, but is not limited to, but it's important to define what those things are. Strategies, marketing data, profits, margins, the kinds of things that are important to your business. You also want to state in that agreement or in that provision why you are disclosing that to the employee. In the course of performing their job, in the course of doing X, Y, and Z, you will be required to provide this information to them. So you want to make it clear to the employee and again to a potential court that it is critical for the employee to have that information, but they have a duty to protect it. And you want to outline in the provision what it is that the employee is supposed to be prohibited from doing. So not just using it, but disseminating it, copying it, theft, disclosure to others. You may want to consider provisions with regard to their use outside of the office or prohibiting the use of cloud-based storage, those kinds of things with regard to your confidential information. Then taking a look at non-solicitation agreements, important things to make sure are in here. Also, make sure you're identifying in the provision the importance of your relationships with your customers, your relationships with your employees, and the employees' involvement in and cultivation of those relationships. So again, they understand and it's crystal clear in a potential enforcement action. Avoid overly broad prohibitions. A lot of times I see a non-solicitation provision that says, hey, employee, when you leave, you can't solicit, do business with, et cetera, any of the company's customers or prospective customers. Now, if that person is the only sales rep for the whole company, maybe that's okay. But if the individual at issue is a sales rep with a defined geographic territory or a defined product line, then this is something that the FTC would say is so broad as to be a de facto non-compete. What you need to be looking at is who they touch, the relationships they touch, the product line they touch. So make sure that those provisions are not overly broad, and certainly consider all necessary geographic restrictions with that as well. in any of these provisions, I think it's important to make sure you have some key, paragraphs and provisions in there, whether it's a non-solicitation, a confidentiality provision, a non-compete, if they survive, but all of the agreements should include a few things if they don't already. And just go to the next slide, please. First of all, they should include an attorney's fee provision, and it should be a one-way provision. There are so many times when I'm reviewing an agreement that a client provides me, and it says, basically the prevailing party is entitled to attorney's fees in any enforcement action. That's not what you want to put in there. You want to include that the company is entitled to recover its attorney's fees in any enforcement action or a successful enforcement action. Certainly, if you have a higher level employee, they may negotiate for that to be mutual, but you don't want to start from a position of mutuality. It doesn't mean you are always going to get attorney's fees awarded by a court. Courts don't always like these types of provisions, but it can be a deterrent, and it can be a good bargaining chip if there's a negotiated resolution to these. Make sure that these agreements are including a notification provision. So you are requiring that employee to notify their new employer of their restrictions for so long as that restricted period continues. They may not do that, but if they don't, that's another sort of quiver in your arrow there that you can use in the event of a potential enforcement action, even if that action is limited to the world of non-solicitations and confidentiality provisions. Also include a tolling provision that would extend the restrictive period in the event of a violation. That way, if you don't find out about it for 6 or 8 months after the employee leaves, you're entitled to reinvigorate that, the term. And again, it may not be enforced by a court, but it certainly is something to provide some leverage, and many courts will apply those types of tolling provisions. Other things to do now have to do with your trade secrets, ever more important for your trade secrets. So now is the time, if you haven't started doing so already, to look into your trade secrets policies and your protection practices. So we'll talk a little bit about that in a moment. But looking at the FTC's final rule and in the guidance with it, the FTC really highlighted the importance of trade secret precautions and basically said, well, we don't need non-competes because businesses have these other types of agreements, and geez, we have this thing called the Defend Trade Secrets Act that provides employers with a means to protect their business interests. We all know that non-solicitation agreements have their place. They are great with regard to employees who have customer interfacing roles, but again, top-level executives, creative folks, scientific people, non-solicits don't provide any protections. Those folks are not out for the most part glad-handing the customers. So you're left with other means to be able to try to protect those interests. And that's why things like the trade secret common law principles and the Defend Trade Secret Act are now of even more critical importance. Remember that under the Defend Trade Secrets Act itself, on the next slide, employers can not only go right into federal court for an action, but also may seek recovery of punitive damages and attorney's fees only if you've included that provision that notifies them that it's okay to disclose trade secret information in a whistleblower process or in a sealed court filing. But if you have that provision in there, that does, again, give you some opportunity and leverage for additional damages and for attorney's fees. So looking at some best practices with regard to trade secrets, again, look through these things now. Think about, do you have protocols in place for the departure of key employees? These things should include, your protocols should include a reminder of all of their obligations. That includes not only their contractual obligations, but their obligations with regard to trade secrets. It's okay and should be in many circumstances a practice to notify the new employer, if you know who that is, that, hey, this employee is coming to work for you. They are under certain obligations to us post-employment. Here's a copy of their agreement. We're going to be monitoring them to make sure that they're in compliance, et cetera, et cetera. Also very advisable to take the time to do an email review. Some think that it's hard to catch anything with an email review over the last 30 or 60 days of their employment because everyone uses personal emails or clouds or all of these things. But it continues to be surprising how much information can be harvested from an email review if someone is going to a competitor when they leave employment. Sometimes that still is emailing themselves documents from your organization, emailing themselves quarterly reports or pricing for customers, those kinds of things. Could be as simple as confirmations of interview dates that if you didn't know that they were going to a competitor. So take the time to harvest that. Take the time to monitor their continuing email activity. You may cut you will be cutting their email off immediately when they leave, but it is astonishing how many customers continue they think they're sending the email to the employee's new email address. They send it to the old email address. So that's how you get tipped off many times. So make sure that those protocols are in place. And certainly with key employees, I always advocate that you don't just wipe that computer and put it back in circulation. At a minimum, preserve the hard drive, take that out of there, put it on a shelf, consider a forensic review. If it is a key employee that you know or suspect is going to work for a competitor, we have vendors who do a review of those. Do not allow your internal team to hop on the computer and start finding information on their own. That changes the underlying metadata, and it is much more difficult then to establish that the employee may have engaged in nefarious activities. Establish your monitoring, or think about establishing monitoring policies with regard to your trade secrets. So there is software that is in place. I work with a lot of clients who have something like this in place where alarms will be triggered upon certain types of use. So maybe it's based upon the number of documents accessed within a certain period of time. If it looks suspicious, red alert goes off and the IT department gets notified. It may be just a routine kind of sporadic monitoring like you would do a drug test, and it could be other suspicious use monitoring. So if key documents are being accessed, every time key documents may be hit, that sends up an alert and you can take a look at it. Review all of your policies on handling of trade secrets. Make sure that they're informing folks of what they need to do to protect them, their duties with regard to them, in their agreements, in your handbooks, in freestanding policies. Make sure things are marked, make sure things are protected. Think about encryption, but also make sure you're reviewing, if you, again, haven't already, your remote work policies now that virtually everybody is a hybrid environment. Are you instructing employees how they handle hard copies of their documents, how they shred them? Where can they have conversations with clients or with internal teams about trade secret information? Do you tell them it has to be in a private room? It can't be in the presence of any third parties. What to do about documents when they're finished with them? Do they bring them back to the office to shred? Policies that talk about the use of their personal devices and not commingling information between their work computers or their personal devices unless you have a personal device use policy, which should provide you access, periodic access to review and delete. So act now with regard to looking at your trade secrets, policies and practices. No matter what happens with this rule, non-competes have been under attack, and trade secret protections are becoming more and more important, and I venture to say will become more and more important in the coming months and years. And that brings us to the end of our prepared presentation. I'm looking to see, I don't see any questions yet. Feel free to post some in the chat if you would like.
Debbie, one question we do have, if you could just speak to a little bit more about the accrual of a potential action here. If the effective date actually does end up being, August 21st, let's say the individual violated the non-compete on August 20th, will the employer still be able to bring suit after the effective date?
It would appear so. The FTC says if that action accrues before the effective date, then the employer can assert an enforcement action. Now, I think that, when you get into that razor thin line between, the activity and the deadline, how are courts going to parse that out? Exactly what does it mean to accrue? Is that, they step foot in the door of a competitor? Is that, they've talked to a customer, they've taken away a customer? I think courts we'll see courts probably all over the place with regard to that. But the FTC says if it happens before the rule goes in effect, then it is fair game. So.
All right.
And Brittany, one clarification with regard to the forfeiture provision, because I think that is something that is maybe a little bit more hidden. Companies think about, oh yeah, here are my non-competes, without necessarily considering the what may be in their those benefits policies. But did I understand you correctly that those notices do apply and are required for the benefits policies as well?
Yeah, and it kind of goes back to the de facto non-compete language that's in the final rule. So essentially, the FTC has found that those forfeiture for competition provisions, even within deferred compensation, will qualify as non-competes under the final rule. And yes, the notice would then be required for those as well.
Great.
All right, we have another question here. So for onboarding employees in the interim period, should employers continue to include non-compete provisions in employment agreements?
Yeah. Well, certainly I think that companies should consult their legal counsel, but from my read of the rule, employers are not prohibited from using non-competes until after the rule goes into effect. So during that interim period, it appears under the rule that that's still fair game. And I think that's an important question because, yes, if the rule goes into effect, you'd have to send out a notice. But if the rule is blocked and doesn't go into effect, and you've, in the meantime, a company has hired a CEO and not signed that person up to a non-compete because of the pending rule, then they're going to be in a much tougher bargaining position afterward to say, okay, hey, new CEO, now we want to sign you up to a non-compete. And you may have to put more money on the table in terms of a bonus. There are some states that don't allow continued employment as sufficient consideration, so they may have to wait until another bonus opportunity or a raise or a promotional opportunity. So it would seem that it's easier to say, give that notice to say, okay, just kidding, than to waive sort of that initial right to have them execute a non-compete and then maybe have a more difficult time doing so down the road.
Yeah, agreed. And I think it's also important to note that as far as the notice is concerned, the FTC actually has typed up a notice that employers can use to send out if the rule does go into effect. And also, it's just really important now for employers to get their arms around who has these existing agreements and provisions out there, so that as we move along, you mentioned that we could see as early as June whether or not there's going to be an injunction that's going to delay or halt altogether this going into effect. But just being kind of ready to move, I think, is the important key here. We have another question kind of to that effect about non-solicitation agreements, asking if it includes current clients and former clients, if that would be too broad. So it's really going to be specific as to that employee and your business and what that really means. So for instance, if it's all current clients and former clients of the entire company, and you have a salesperson who's only working with a specific subset of those, it likely would be too broad. I think the most success we see with enforcing these non-solicitation provisions is when it's really focused on those clients and customers that former employee actually worked with, had access to, had information about. So really, just kind of speaking, unless you have a small business or something that they worked with all of the customers, you really kind of want to take a closer look and see how you can narrow that, because again, even if this FTC rule doesn't go into effect, there is a lot of states out there, depending where your employee is, that really, have taken great effort to kind of carve these non-solicitation and confidentiality provisions down to be really specific, to not, overly restrict an employee.
Another thing that I think is important to consider is that, Brittany, you talked about the pending litigation, and I think, it's not a zero-sum proposition. I mean, I don't think we should think of this as either we're going to see a complete block of the rule, or the rule's going to stand in totality. I think it's possible that you see injunctive relief that perhaps leaves the rule in place for certain categories of employees, but not for others. I think we'll see how that plays out. But while companies are doing kind of this deep dive about, okay, who has non-competes, it would be important as part of that process to say, okay, and what's their compensation? What is their position level, both in anticipation of what permutations there may be of the rule, and if they are a multi-state employer, to make sure that they are in compliance with any state laws that may continue to be in place.
Right, and I think another question, there's a couple of them on this, asking about non-executive employees. So the FTC final rule would apply to virtually all employees. So if there's any type of non-compete provisions that would apply to even non-executives, this final rule would require notice to those employees prior to the effective date that those provisions are no longer going to be enforceable. It's just the carve out, the kind of biggest takeaway that's going to affect most people is that senior executive carve out, which just says if you have a non-compete with a current employee that meets the senior executive definition, that it will not be retroactive, meaning after the effective date, you can still rely on that non-compete provision. After the effective date, you won't be able to enter into new agreements, including non-compete provisions, but the retroactivity does not apply to those senior executives. So the final rule will apply to virtually all employees, executives, non-executives, but that specific exception regarding retroactivity is just for the senior executives.
Which is another factor in favor of, if you're onboarding senior execs in this interim period, to go ahead and sign them up to a non-compete, because as long as it's entered into during this interim period, the ability to enforce it would still be there post-rule.
All right. I think that really sums up the questions we've received. If there are specific questions kind of diving into the nitty-gritty that apply to individual businesses, we can follow up offline as well.
Yep, you can also email or call your regular Thompson Hine lawyer. If you're not a current Thompson Hine client, please contact us if you have any questions, and we can discuss available options to address your needs. Thank you all so very much for joining us, and enjoy the rest of the day.